pouvez prendre place.
Good afternoon. The court is in session. Could the registry call the roll, please?
Je vous remercie, Monsieur le Président.
Most obliged, Mr. President. Trial Chamber 1 of the International Criminal Tribunal for Rwanda, composed of Judge Eric Mose presiding, Judge Jai Ram Reddy, and Judge Seige Egorov, is sitting this day, Friday, 2nd of June, to render judgment in the matter of the prosecutor versus Joseph Serugendo. Case number ICTR-2005-84-T. Thank you.
Thank you very much. Could the parties place themselves on record? Prosecution, please.
For the prosecutor, appearing as Stephen Rapp, Chief of Prosecutions, and William Egby, the senior trial attorney, and just to mention today the trial attorneys that are with us, Veronique Wright, Suleiman Khan, and Patrick Kabaki. Thank you.
Thank you. The defense? Your microphone, Mr. Maruma.
Sorry, Milan. Cecil Maruma, Defense Counsel, assisted by Abaizigira Marigoret.
Thank you very much. We will now read out a summary of the judgment, which will be available shortly. It's, of course, the judgment which is the authentic version. Joseph Serugendo was born in 1953. In July 2005, he was indicted by the ICTR prosecutor with conspiracy to commit genocide, complicity to commit genocide, direct and public incitement to commit genocide, and persecution as a crime against humanity. In September 2005, he was arrested and later transferred to the tribunal. During his initial appearance, he pleaded not guilty to all 5 counts. Serugendo immediately commenced discussions with the prosecution with a view to full cooperation and an eventual guilty plea. A joint motion for consideration of a plea agreement between Serugendo and the prosecution was filed on 12 January 2006. On the same day, the prosecution also requested leave to amend the indictment. The proposed amended indictment sought to withdraw 5 charges and to retain 2 counts. A plea agreement was filed jointly on 16 February 2006. Serugendo agreed to plead guilty to counts 1 and 2 of the proposed amended indictment, alleging direct and public incitement to genocide pursuant to Article 2.3c and 6.1 of the Statute of the Tribunal, and persecution as a crime against humanity pursuant to Article 3h and Article 6.1 of the statute. At a plea hearing of 15th March 2005, the prosecution motion to amend the indictment was granted by the Chamber. Serugendo pleaded guilty to the amended indictment. The Chamber found that the plea was voluntary, informed, and unequivocal, and entered a finding of guilt for each count to which Serugendo had pleaded guilty. Following sentencing briefs from both parties, a sentencing hearing was held yesterday on 1st June 2006. After these introductory remarks, I will now give an overview of the facts of the case. Mr. Serugendo was a member of the Comité d'Initiative, the governing board of Radio-Télévision Libre des Mille Collines. He was the advisor on technical matters to the RTLM radio station, chief of the maintenance section of Radio Rwanda in the Office Rwandais d'Information, and a member of the enlarged National Committee of the Interahamwe za MRND that exercised authority over the Interahamwe in Kigali. Serugendo has acknowledged that from early 1992 through 1994, as a member of the Interahamwe, he planned with other leaders of the MRND and the Interahamwe militias political meetings and rallies aimed at inciting members of the Interahamwe to kill or cause serious harm to members of the Tutsi population with the goal of destroying the Tutsi ethnic group. Mr. Serugendo admits that during this period he and others planned to establish, fund and operate the RTLM as a radio station which disseminated an anti-Tutsi message intended to foment racial hatred and ultimately to destroy the Tutsi ethnic group. Mr. Serugendo admits that during 1993 and 1994, the RTLM broadcasted messages aimed at disseminating an anti-Tutsi message, and that such broadcasts in fact incited the killings of hundreds of thousands of civilian Tutsi throughout Rwanda. He has also admitted that as a member of the Comité d'Initiative, the governing board of RTLM, and as an advisor on technical matters, he aided and abetted broadcasts by RTLM employees during the period when it was on air from July 93 to July 94. He accepts to have gone to the RTLM studios accompanied by armed militia to offer technical assistance and moral encouragement to ensure that RTLM broadcasting continued uninterrupted. Following the destruction of the RTLM transmitter in Kigali around 4th July 1994, RTLM technicians under the authority of Serugendo took the equipment salvaged from Kigali to the top of Mount Muhe near Gisenyi and used the transmission equipment installed previously on Mount Muhe to create a makeshift studio, thus allowing RTLM broadcast to resume. In the same period, he provided technical expertise that enabled RTLM journalists to record programs calling for the extermination of Tutsi on tapes, which were then broadcast over RTLM from Mount Muhe. He admits that as a member of the Comité d'Initiative, this governing board, and as an advisor, he exercised authority over RTLM technical employees and other support staff. He acknowledges that he was at all material times aware of the persecution of some persons on political grounds and of mass discrimination against the Tutsi. He admits that despite this knowledge, he nevertheless continued to work with the RTLM and to discharge his functions. The Chamber has found that both the actus reus and the mens rea of the crimes to which the accused has pleaded guilty have been established. The Chamber will now turn to the sentencing. Amongst aggravating circumstances are the seriousness of the crimes and the extent of the involvement of Serugendo in their commission. Genocide and crimes against humanity are inherently aggravating offenses because they are heinous in nature and shock the collective conscience. Serugendo's position as a member of the managerial staff of the RTLM, the authority he therefore exercised over the personnel of the radio station, and his active role in ensuring the proper functioning of the radio station are aggravating factors. The Chamber notes that Mr. Serugendo was not a particularly high-ranking or influential personality in Rwanda in 1994, nor did he personally make any anti-Tutsi or inflammatory statements over the RTLM or commit any violent acts during the massacres in Rwanda. The Chamber will now turn to mitigating circumstances. We will start with Mr. Serugendo's guilty plea. Here, the Chamber concurs with previous decisions of this tribunal that some form of consideration should be given to those who have confessed their crimes in order to encourage others to come forward. Moreover, the Chamber is of the view that the guilty plea of the accused may contribute to the process of national reconciliation in Rwanda. Further, by pleading guilty prior to the commencement of the trial, the accused relieved the victims of the need to open old wounds. The Chamber finds that Serugendo's change of plea to one of guilty is a mitigating circumstance. The plea was accompanied by publicly expressed acknowledgement of his responsibility. Further, the timely nature of the guilty plea facilitates the administration of justice and saves the tribunal's resources. The next points relate to Mr. Serugendo's cooperation with the prosecution. Both the prosecution and the defense concur that Serugendo has provided substantial cooperation to the prosecution. This cooperation is described as wide-ranging and substantial, leading to the clarification of many areas of investigative doubt, and including in relation to crimes previously unknown by the prosecution. Consequently, he can be seen as setting an example that may encourage others to acknowledge their personal involvement in the massacres that occurred in Rwanda in 1994. Based on the submissions of the parties, it's clear that Serugendo's cooperation with the prosecution has been substantial. The trial chamber finds this to be a significant mitigating circumstance. Remorse. Both in the plea agreement and during the sentencing hearing, Serugendo publicly expressed regret and remorse for his crimes. The Chamber accepts that this remorse is genuine and finds his expression of remorse to be one mitigating factor amongst others. Furthermore, both parties note that, as far as is known, Serugendo was of good character and had no record of extremism before 1994. The accused has no previous criminal record, a factor to be taken into account for mitigation. As for personal and family circumstances, the Chamber notes that Mr. Serugendo is married and that he is 53 years old. It considers that these factors taken together amount to personal circumstances of a kind which may be accorded some, although very limited, weight in mitigation. Turning to assistance given to certain victims, the defense called witness AX, the Tutsi, who testified that on 10th or 11th April 1994, he was chased by armed attackers. Mr. Serugendo rescued the witness by transporting him in his car and refusing to relinquish him to the angry mob. The evidence was uncontested by the prosecution. The Chamber accepts that Mr. Serugendo saved the life of witness AX during the genocide as a factor in mitigation. Ill health is a consideration in the present case. Mr. Serugendo has been recently diagnosed with a terminal illness. Both parties concur that his fragile health and poor prognosis must be taken into account in determining a fair sentence. The Chamber has noted the content of the confidential medical report, which was tendered by the accused into evidence during the sentencing hearing yesterday. This report suggests that the accused is suffering from an incurable and inoperative condition, and that his life expectancy is accordingly reduced. Further, he is likely to require intensive ongoing medical treatment and palliative care. Ill health has been considered as a mitigating factor in sentencing by both this tribunal and the Yugoslav tribunal. The weight it has been accorded has varied. There is no case law concerning the significance of terminal illness. Although both parties view Mr. Serugendo's state of health as a significant mitigating factor, they do not seek medical care as an alternative to confinement. They submit, however, that irrespective of the sentence to be imposed, the accused must continue to be provided with medical treatment, including referral to appropriate facilities where necessary. The Chamber considers that the accused's current state of health, as established by the medical report, constitutes a significant mitigating circumstance in sentencing. Further, the care and ongoing treatment necessary to deal with his condition requires a modified regime of detention. Other considerations include the sentencing practice in the courts of Rwanda. The Chamber has also noted the sentencing recommendations of the parties. In the plea agreement, the prosecution undertook to recommend a sentence of between 6 and 14 years imprisonment. At the sentencing hearing yesterday, the prosecution revised this range and proposed a sentencing range instead of 6 to 10 years, given the substantial nature of the cooperation received from Joseph Serugendo. Although the Chamber is not bound by the recommendation of the parties, the Appeals Chamber has nevertheless emphasized that trial chambers shall give due consideration to the recommendation of the parties and, should the sentence diverge substantially from that recommendation, give reasons for the departure. The Chamber is then of the view that despite the gravity of the accused's crimes and his official position, significant mitigation is warranted in view of Mr. Serugendo's guilty plea with publicly expressed remorse and his substantial cooperation with the prosecution. His family situation, his good character prior to these events, his lack of prior criminal convictions, and his age, while they are factors in mitigation, are of substantially less weight. By contrast, the Chamber finds Mr. Serugendo's ill health and consequently reduced life expectancy and quality of life to be a significant factor in mitigation. It is noted that the plea agreement and its recommendations as to sentence, which was filed jointly, was later revised by the prosecution, including a lower sentencing range in view of Mr. Serugendo's substantial cooperation. The Chamber is not bound by this recommendation, as already mentioned, but it is of assistance. And the Chamber finds that Mr. Serugendo should be given a sentence at the lower end of the recommended range and will decide accordingly. This said, it is clear that Serugendo is not in a position to serve a sentence under normal prison conditions. He has recently been diagnosed, as already mentioned, with a terminal illness. He has very fragile health and a very poor prognosis. The tribunal must continue to ensure that he receives adequate medical treatment, including hospitalization to the extent needed. This should also be reflected in the disposition of the judgment. And the judgment then concludes that for these reasons, having considered the arguments and the evidence presented by both parties, the Chamber sentences Joseph Serugendo to a single sentence of 6 years imprisonment and instructs the registry to ensure that Mr. Serugendo shall continue to receive adequate medical treatment, including hospitalization to the extent needed. Mr. Serugendo, pursuant to Rule 101C of the rules, shall receive credit for his time served, which the Chamber has calculated as 260 days. This marks the end of these proceedings. The court is adjourned.
All right.